The Maryland Public Service Commission is on the record in docket number RM78. By notice issued on April 12, 2023, this is the time and place for the Commission to consider final adoption of regulations relating to retail energy supply offers to low-income customers. On October 27th, November 2nd, and November 9th of 2022, the Commission held hearings to review proposed regulations and subsequently voted to publish the draft regulations in the Maryland Register. The proposal was published in the Maryland Register on March 24, 2023, seeking public comment. Those comments were due on April 24, 2023. The sole timely comment was filed jointly by RESA, the Retail Energy Supply Association, and NRG. Various reply comments were filed in response to the RESA and NRG joint filing, as well as comments that were cross-filed in other dockets, including RM80, which we will hear tomorrow, as well as PC 55. Do any parties wish to be heard before I call a motion today? Mr. Wallace, good afternoon.
Yeah, good afternoon, Chairman, Commissioners. Eric Wallace on behalf of the Retail Energy Supply Association and NRG, Inc. We made two filings in this phase of the rulemaking. The first was on April 24th. In that filing, the issue that we raised was the overlap between the regulations being contemplated in this rulemaking in RM78 and the related issue of the retail choice options for shopping customers under the CCA program that's being considered in tomorrow's rulemaking. And the request that we made was that the Commission clarify the relationship between the two, and specifically in the scenario where the CCA selects a licensed third-party retail supplier to serve CCA aggregation customers. In that situation, there would be both the CCA and a retail supplier involved in the service to customers. And the issue that comes up is low-income customers that would be served by a third-party retail supplier in Montgomery County as part of that CCA arrangement. And so there are two statutory provisions at issue, the CCA legislation and also the legislation that's at issue in this rulemaking that prompted this rulemaking proceeding. RESA and NRG's position is that the low-income energy assistance statute does not exempt suppliers that are serving CCA customers, and the CCA statute does not exempt suppliers that are selected by a CCA to serve low-income customers in Montgomery County. And so we've requested that the Commission consider adopting a regulation in this proceeding, either in this rulemaking phase or in a subsequent phase, or in the RM80 rulemaking, which could happen tomorrow, to clarify that relationship and confirm that to the extent a supplier, a licensed third-party retail supplier, is serving customers as part of the CCA, as the selected supplier, that supplier will need to comply with the energy assistance requirements and restrictions by statute that apply to all third-party retail suppliers in Maryland, whether they are operating on their own or if they are selected by a CCA to serve customers in Montgomery County, and that is consistent with the legislative language in both statutes, and make sure that there's sort of a level playing field so that suppliers are not, serving low-income customers in the county, charging more than retail, the SOS rates through the CCA, but then, their competition cannot do so.
Just to be clear, Mr. Wallace, you're not seeking to disturb the proposed rule before the Commission today?
We proposed language for the Commission to consider depending on the path forward here. So we included language, red line language, in our regulations. We certainly understand that there's been a lot of process to this point, and this is the final rulemaking to consider the proposed regulations. We provided language for the Commission to consider if you're inclined to reopen the regulations and make that change now. The other options would be to publish the regulations, the final regulations now, and revisit this issue in a future phase of this rulemaking, or in the RM80 rulemaking tomorrow. It's an issue that crosses both rulemakings, and so any one of those procedural options would be a path to address this issue.
Well, we do have RM80 tomorrow, and there is obviously the overlap here on this issue. There will also, as you noted, be a phase 2 of this proceeding where this issue could be addressed if your issue is not addressed to your satisfaction in tomorrow's rulemaking regarding the aggregation law in Montgomery County. Your second issue, Mr. Wallace?
The second issue we raised involved the grandfathering for retail supply contracts that are in place and executed prior to July 1st. This was an issue that we addressed in prior comments, and that was part of the discussion during the rulemaking sessions that the Commission had in this proceeding last fall. This issue was also something that was addressed through the PC 44 Customer Choice and Competitive Markets Work Group in the communications plan that was developed and filed in March and approved in April. We filed a letter yesterday bringing this issue to the Commission's attention. It's an important one for suppliers that are heading into July 1st to understand, what the scope of grandfathering is. The uncertainty was created on this issue on May 19th when the Consumers Affairs Division issued a interpretive guidance memo that shifted the grandfathering language that the Commission had approved in the communications plan, and from what our interpretation of the scoping language in the regulations, and effectively what CAD's memo would to
Mr. Wallace, let me stop you there. So the Commission approved the customer communications plan back on April 12th. Is that correct?
That's correct, sir.
And did we not address this issue at a previous rulemaking session this spring?
We addressed this issue during the April 12th administrative meeting. The rulemakings for these regs concluded in November of last year. So I don't know if we would consider the April 12th discussion a rulemaking discussion.
If I recall, you and I had a dialogue, and you were satisfied with the guidance provided from the bench at the time. Is that right? And the only thing that has changed between that session and today is that the director of CAD has issued a letter?
That's correct. Yeah. And so we attached that letter. That letter imposes a new standard where longer duration retail supply contracts that include an ETF would be the only ones to be grandfathered. That is not something that was previously discussed, and that doesn't make sense under the rules. So that was what prompted us to make the filing yesterday.
And I know why you made the filing, and it was incumbent upon you to do so. The Commission did provide you with the guidance that you sought, and not to drag this out any longer, I understand that the CAD director is going to be issuing a revised CAD interpretation letter in the near term, which will likely ameliorate your concerns.
Okay. Thank you.
Thank you, Mr. Wallace, for bringing that to the attention. It's a complicated, 6 levels deep complicated issue that I don't think we need to spend any more time on. Okay. Thank you. Any other parties wish to undo the regulations before the Commission today? Mr. Auslander.
Good afternoon, Mr. Chairman. Jacob Alcenter on behalf of the Maryland Office of People's Counsel. I stood up before I heard the last part of your sentence. OPC supports the rules as published in the Maryland Register and would request that the Commission finally adopt them today.
You scared me. Thank you. As noted, these will be evolving. There will be a phase 2 of this proceeding, but with July 1st looming on the calendar and a statutory deadline that this Commission is subject to, I would move that the Commission finally adopt the draft regulations amending Comar Title 20, subtitles 51, 53, 54, and 59, as published in the Maryland Register on March 24th, 2023, inclusive of any non-substantive changes necessary to conform to Comar drafting requirements. The vote begins with Commissioner Linden.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard. Aye. I vote aye. The motion is approved. As Mr. Wallace noted, we will be having a somewhat interrelated rulemaking session tomorrow on RM80. I do not expect it to be 10 minutes long. So for those participating, please plan to be with us for the entire day tomorrow. Rulemaking session 78 is adjourned.